Hello and welcome to BYJU'S Exam Prep. On August 5 and 6, 2019, the relationship between Jammu and Kashmir and the Union of India was altered. How? Number one, the special status accorded to Jammu and Kashmir under Articles 370 and 35 capital A was revoked. While Article 35 capital A was made to disappear, Article 370 was de-operationalized. In other words, Article 370 was not abrogated, was not deleted, it was rendered inoperative. Number one. Number two, the then state was downgraded and bifurcated into union territories. The union territory of Jammu and Kashmir, which will have a legislative assembly, and the union territory of Ladakh without a legislative assembly. All this was done when the erstwhile state was under the central rule, when the president's rule was in operation under Article 356 of the Constitution of India. Numerous petitions were filed in the Supreme Court challenging the constitutional validity of these actions. And on December 11, 2023, a 5-judge constitution bench of the Supreme Court, headed by the Chief Justice of India, Justice Chandrachud, upheld most of these actions. One action was declared unconstitutional by the top court, one question was left unanswered by the Supreme Court, and all other questions were answered in favor of the union government by the apex court. In this lecture, we will discuss all that you need to know regarding the Supreme Court verdict on Article 370. But before that, I urge you to press the like button, like this video, drop in your comments, and subscribe to our YouTube channel if you haven't yet. Let's get started, but first up, let's look at the history. How Article 370 made its way into the Constitution of India. What is the history behind Article 370? All that we have discussed in great detail in one of my earlier videos. The link to that video is provided in the comment section, is provided in the video description as well. Please go through that video should you wish to understand the detailed history of Article 370. But today, in this lecture, I will briefly summarize what Article 370 was so that you are able to understand the Supreme Court judgment. There were more than 550 princely states during the colonial period during British India. One such princely state was Jammu and Kashmir. When Indian Independence Act 1947 was enacted, two independent dominions were created, India and Pakistan. These princely states, they were given options: join either of the two dominions of India or Pakistan, or stay independent as well. But this decision, whether to join the dominion of India or Pakistan or to stay independent, this decision was to be taken by the ruler, not by the subjects, not by the people. And thanks to Sardar Vallabhbhai Patel, majority of these princely states decided to join and accede to the Union of India. But Jammu and Kashmir, which was headed by the ruler Maharaja Hari Singh, decided against joining either of the two dominions and stayed independent. So Jammu and Kashmir retained its independence for 73 days beginning August 15, 1947, because Maharaja Hari Singh decides against joining either of the two dominions and retained independence, remained an independent political entity. But then things changed. Pakistan invaded Jammu and Kashmir and wanted to forcibly acquire Jammu and Kashmir. Within Jammu and Kashmir, Maharaja Hari Singh was facing another problem, another trouble. And this trouble was led by the then popular leader of Jammu and Kashmir, Sheikh Muhammad Abdullah, who was also known as the Sher-e-Kashmir, the Lion of Kashmir. And he led a popular movement against the Dogra rule, against the monarchy, and wanted to establish democracy in Jammu and Kashmir. Sheikh Muhammad Abdullah started a political party known as the Muslim Conference. But to elicit the support of non-Muslims, to appear secular towards the wider public, he changed the name of his political entity from Muslim Conference to National Conference. And Sheikh Abdullah and Pandit Nehru, they were friends. Pandit Nehru had Kashmiri ancestry as well. His ancestors were from Kashmir. And both these individuals were secular to the core. They rejected Muhammad Ali Jinnah's two-nation theory, wherein Jinnah said that Hindus and Muslims are two separate communities with different ideologies, different aspirations, and they cannot be welded into a single nation. That is why, in the name of Islam, a new country, Pakistan, should be born, should be created. But Sheikh Abdullah and Pandit Nehru rejected this idea, and Sheikh Abdullah wanted Jammu and Kashmir to be part of the Union of India. So Maharaja Hari Singh, who decided to stay independent, but was facing twin problems. The external enemy, Pakistan, has invaded Jammu and Kashmir, and internally there is a popular movement for democracy, for the end of monarchy in Jammu and Kashmir, led by Sheikh Muhammad Abdullah. And ultimately what happened? Maharaja Hari Singh signed an instrument of accession. And through this instrument of accession, which was signed on 26th of October 1947, Jammu and Kashmir became part of India. But listen to me carefully. This instrument of accession basically said that there are three powers transferred to the central government, transferred to India. That means the Parliament of India will be empowered to make laws for Jammu and Kashmir only with respect to defense, external affairs, which means foreign policy, and communication. A proclamation was issued by Maharaja Hari Singh saying, I will retain sovereignty over all other aspects of Jammu and Kashmir. Only three powers have been transferred to India, which means the Parliament of India is empowered to make laws on only three items: defense, external affairs, and communication. On all other aspects, I retain the sovereignty, I retain the independent decision-making power. Similar instrument of accession was signed by almost all the other princely states who decided to join the Union of India. So listen to me carefully. The princely states, when they had to accede to the Union of India, they signed similar instrument of accession. But later on, they signed another agreement known as the merger agreement. What is the difference? Princely states, they signed instrument of accession, transferred three powers to the government of India: defense, external affairs, communication, while retaining powers over other subjects. So that means through instrument of accession, princely states became part of the Union of India, but then they also signed another agreement known as the merger agreement. And when they signed this merger agreement, that means they gave up any semblance of sovereignty and merged with the Union of India. That means they did not retain any element of sovereignty. Jammu and Kashmir was the only princely state which signed only the instrument of accession but did not sign the merger agreement. Why? Because things were different. Pakistan invaded Jammu and Kashmir. And under these unique circumstances, Jammu and Kashmir became part of India. But then the government of India decided to approach United Nations. United Nations, which was born in 1945 after the Second World War, to ensure that there is no repeat of another war, so that another war is not thrust on the people of this world, United Nations was born. And after the Second World War, the world became bipolar as well. Two superpowers emerged on the world scene. On one hand, we had the power bloc of United States. On the other hand, USSR, Soviet Russia. Pakistan then decided to join the power bloc led by United States. United Nations, it is still under the control of United States. It was then also under the writ of United States. So since United States controlled United Nations, United States and Pakistan, they got friendly to each other. United States decided to support Pakistan in the United Nations Security Council. And the United Nations Security Council passed a resolution calling for a plebiscite in Jammu and Kashmir. What is this plebiscite? The decision whether to join dominion of India or Pakistan or to stay independent. Who had to take this decision? The ruler, not the subjects, not the people. United Nations Security Council said there should be right to self-determination. Let the people of Jammu and Kashmir decide whether they want to join India or they want to join Pakistan. This decision should be taken by the people, not by the ruler. And at the same time, the government realized the mistake of approaching the United Nations. The government was not in favor initially of approaching the United Nations, but then because of various reasons approached United Nations Security Council, but then it was under the writ of United States. Why United States did not support India? Because after the Second World War, after India became independent, India decided that we will chart out our independent foreign policy. We will not align to either of the two power blocks of US or USSR. We will have a non-aligned foreign policy. We will not align to any of these two power blocks. But since Pakistan was getting closer to United States supported Pakistan, which means United Nations Security Council passed a resolution calling for plebiscite in Jammu and Kashmir with some conditions. Conditions such as that Pakistan should withdraw its troops from Jammu and Kashmir, then India will also withdraw its troops from Jammu and Kashmir, and then there will be a vote where people will decide whether to join India or Pakistan. But then the government of India decided that we will give a constituent assembly to Jammu and Kashmir. Let Jammu and Kashmir enact its own constitution. And it is this Jammu and Kashmir constitution enacted by the Jammu and Kashmir Constituent Assembly which will define the relationship between the Union of India and the state of Jammu and Kashmir. So under this unique circumstance, Jammu and Kashmir acceded to the Union of India. The matter went to the United Nations Security Council. Security Council is calling for a plebiscite. Ultimately, the government of India decided, let's have a constituent assembly in Jammu and Kashmir. Let them frame their own constitution, and that constitution will define the relationship between the government of India and the state of Jammu and Kashmir. But constituent assembly is to be created. Then constituent assembly has to work many years to frame and enact its own constitution. Creating a constitution is a time-consuming affair. Till the time Jammu and Kashmir Constituent Assembly frames its own constitution, what should be the relationship between India and the state of Jammu and Kashmir? For that, the Constituent Assembly of India decided to enact a temporary provision known as Article 370 of the Constitution. Why temporary? Because the relationship of Jammu and Kashmir with the Union of India has to be decided by the people of Jammu and Kashmir through their 75 members in the Jammu and Kashmir Constituent Assembly. But it is going to take some time. We have our Indian Constitution in 1949. Jammu and Kashmir Constituent Assembly will take time to write, draft, enact its constitution. Till that time, what should be the relationship between Jammu and Kashmir and the Union of India? For that, let's have a temporary provision known as Article 370. And what was this Article 370? It said, only Article 1 and Article 370 will apply to Jammu and Kashmir. So all the articles that are present in Indian Constitution, not all articles of Indian Constitution apply to Jammu and Kashmir, only two articles will apply. Article 1, which says India, that is Bharat, shall be a union of states, which means Jammu and Kashmir is an integral part of India. And Article 370 will apply to the state of Jammu and Kashmir. In the instrument of accession, there were three powers given to the Parliament of India: defense, external affairs, communication. So there is something known as Schedule 7 of the Constitution: union list, state list, concurrent list. Who has the power to make a law on state list and concurrent list? Jammu and Kashmir legislature. Who has the power to make a law on any item mentioned in the union list as well? Jammu and Kashmir legislature. Except three items: defense, external affairs, and communication. But can other items mentioned in the union list be also made applicable to the state of Jammu and Kashmir? Yes. How? For that, President will have to issue an order, but this order should be issued with the concurrence of the government of Jammu and Kashmir. I'll repeat. Article 370 basically said only Article 1 and Article 370 shall apply to the state of Jammu and Kashmir. This is for a temporary period till Jammu and Kashmir Constituent Assembly defines the relationship between the Government of India, between the Union of India and the state of Jammu and Kashmir. But in Union list, if only 3 items are transferred to the Parliament, what about other items mentioned in the Union list? There are 97 items in the Union list. If only 3 items, defense, external affairs and communication, have been transferred to the Parliament of India, what about other 94 items? Can these items be also made applicable to the state of Jammu and Kashmir? Yes. How? For that, President will have to issue an order under Article 370 and apply other items in the Union list to the state of Jammu and Kashmir, but only with the concurrence of the government of Jammu and Kashmir. That was one. Second, if only Article 1 and Article 370 apply to Jammu and Kashmir, that means Article 3 does not apply to Jammu and Kashmir. Citizenship chapter does not apply. Fundamental rights does not apply. Directive principles, they don't apply. Supreme Court is not applicable. Finance Commission is not applicable. Election Commission of India is not applicable. Finance Commission, CAG is not applicable. Can other articles of Indian Constitution, other than Article 1 and 370, be also made applicable to the state of Jammu and Kashmir? Yes. For that, what is the procedure? Same. President will have to issue an order, presidential order under Article 370, but again with the concurrence of the government of Jammu and Kashmir. No amendment of Indian Constitution will automatically apply to the state of Jammu and Kashmir unless and until the state government gives its concurrence. And then it had a self-destruct clause as well. Article 370, clause 3. Notwithstanding anything mentioned in this article, this Article 370 shall cease to operate or shall operate with such exceptions and modifications as the President may by order specify. That means Article 370 will not continue forever. It can cease to exist or it will exist with some modifications as the President in its order specify. But this presidential order cannot be issued by the President without the concurrence of the Constituent Assembly of Jammu and Kashmir. Article 370 further said, if other parts of Indian Constitution, such as fundamental rights, are made applicable to the state of Jammu and Kashmir, how can we make fundamental rights chapter applicable to the state of Jammu and Kashmir? President will have to issue an order under Article 370, apply fundamental rights to Jammu and Kashmir. But that does not mean that the entire chapter of fundamental rights be made applicable to Jammu and Kashmir the way it is applicable for the rest of the country. This chapter of fundamental rights can be made applicable to the state of Jammu and Kashmir, but with exceptions and modifications. With such exceptions and modifications as the President in its order specify. And I will explain what is that exception, what is that modification. But this is what Article 370 was. Only Article 1 and Article 370 will apply to Jammu and Kashmir. Can other articles apply? Yes. President will have to issue an order with the concurrence of the state government, apply other provisions of Indian Constitution to the state of Jammu and Kashmir with some exceptions and modifications. Only 3 items are transferred to the Parliament: defense, external affairs, communication. Can other items in the Union list be made applicable to the state of Jammu and Kashmir? Yes. For that, what is the procedure? President will issue an order under Article 370, apply other items of the Union list to the state of Jammu and Kashmir with the concurrence of the government of Jammu and Kashmir. But Article 370 itself can cease to exist or can exist with some exceptions and modifications. But this order cannot be issued by the President without the concurrence of the Constituent Assembly of Jammu and Kashmir. This is how Article 370 was born and incorporated into the Constitution of India. But then some changes happened. Presidential Order of 1954 was issued. What is this Presidential Order of 1954? There were talks between the representatives of Jammu and Kashmir, initially led by Sheikh Abdullah, then by Bakshi Ghulam Muhammad, and the government of India. Because if right now only 3 items are transferred to the Parliament, Defence, External Affairs, Communication, only 2 articles are applicable to Jammu and Kashmir, Article 1 and Article 370. But how do we integrate Jammu and Kashmir with the Union of India? How do we make fundamental rights applicable, directive principles applicable, Election Commission applicable, CAG applicable, Finance Commission applicable, emergency provisions applicable? How do we make other provisions of Indian Constitution applicable to the state of Jammu and Kashmir? For that there were negotiations. And these negotiations led to President issuing an order under Article 370, and this is known as the Presidential Order of 1954. And it is this Presidential Order of 1954 which has been modified numerous times. Numerous times since 1954. It is through this Presidential Order of 1954 that Finance Commission was made applicable, Election Commission was made applicable, Supreme Court was made applicable, CAG was made applicable, fundamental rights were made applicable to the state of Jammu and Kashmir. Because how can you make other provisions of Indian Constitution apply to the state of Jammu and Kashmir? For that, President has to issue an order under Article 370 with the concurrence of the government of Jammu and Kashmir. Government of Jammu and Kashmir gave its concurrence, and through these talks, through these deliberations, one by one, various provisions of Indian Constitution were made applicable to the state of Jammu and Kashmir. And to tell you, if there are 97 items mentioned in the Union list, and in 1949, in 1950 when the Constitution was enacted, if only 3 items were transferred to the Parliament of India, on the morning of August 5, 2019, 94 of 97 items were made applicable to Jammu and Kashmir. So that means it is this Article 370 through which Constitution of India flows into the state of Jammu and Kashmir. If there was no Article 370, Indian Constitution could not have been made applicable to the state of Jammu and Kashmir. Now, President issued various orders under Article 370, and through these orders, one by one, various provisions of Indian Constitution were made applicable to the state of Jammu and Kashmir. And to give you an illustration, on the morning of August 5, 2019, 94 out of 97 items mentioned in the Union list were made applicable to the state of Jammu and Kashmir. Jammu and Kashmir Constitution itself was adopted in 1956. Constituent Assembly of Jammu and Kashmir drafted its constitution for Jammu and Kashmir and overwhelmingly said Jammu and Kashmir is and shall remain an integral part of India. And once this Constituent Assembly of Jammu and Kashmir enacted its constitution, it was also dissolved. Just like the Constituent Assembly of India was dissolved after it gave India its constitution. Similarly, the Constituent Assembly of Jammu and Kashmir, once its job was done, it enacted the constitution for Jammu and Kashmir, which defined the relationship between the Union of India and the state of Jammu and Kashmir. This Constituent Assembly was also dissolved. But before its dissolution, it did not recommend any action on Article 370. Because Article 370, Clause 3 says, Article 370 shall cease to exist or shall exist with such exceptions and modifications as the President in its order specify. But before its dissolution, the Constituent Assembly of Jammu and Kashmir did not recommend any action, any modification of Article 370. Then something else happened. Puranlal Lakhanpal, 1962. What did I tell you? Can other provisions of Indian Constitution be made applicable to the state of Jammu and Kashmir? Yes. But these provisions can be made applicable to Jammu and Kashmir with some exceptions, with some modifications, as the President in its order specified. What was that modification? I'll discuss 2 important modifications. Modification number 1, we have Lok Sabha. How are the members of Lok Sabha elected? Direct election. That means every 5 years, general election takes place. People of this country directly elect their 543 representatives to Lok Sabha. But for Jammu and Kashmir at that time, members to Lok Sabha from Jammu and Kashmir were indirectly elected. Not directly elected by the people, indirectly elected. Matter went to the court. Supreme Court, how is it possible that for the rest of the country, Lok Sabha MPs are elected directly by the people, but for Jammu and Kashmir, Lok Sabha MPs are indirectly elected? How is this possible? The government said it is because of presidential order. President can issue any order under Article 370 and apply other provisions of Indian Constitution to Jammu and Kashmir, but with some exceptions, with some modifications. The petitioner said that these modifications can only be minor. These can be minor modifications. Supreme Court said no. The presidential order under Article 370, the power given to the president is wide amplitude. Wide amplitude powers are given to the president under Article 370. It can modify any provision of Indian Constitution in its application to Jammu and Kashmir. That was Puranlal Lakhanpal 1962 case. Not just this, one exception was Article 35 capital A of the Constitution of India. What is Article 35 capital A? This article, which was part of Indian Constitution, was not applicable to any other state in India, was applicable only to the state of Jammu and Kashmir. Under Article 35 capital A, the legislature of Jammu and Kashmir was empowered. Empowered with that you can recognize who are your permanent residents. And once you have identified who are your permanent residents, then you can give them some benefits. Benefits such as only the permanent residents of Jammu and Kashmir can buy land, can buy property in Jammu and Kashmir, can apply for government jobs in Jammu and Kashmir, can get government scholarships in Jammu and Kashmir. But what about fundamental rights chapter? Fundamental rights, particularly under Article 19 of the Constitution, are applicable only to the citizens. Every single citizen of this country, he or she has the fundamental right to move freely throughout the territory of India, to reside and settle anywhere within the territory of India. Under Article 16, every citizen has the equal opportunity in public employment. So if every citizen has an equal opportunity to reside and settle anywhere within the territory of India, why in Jammu and Kashmir, non-Jammu and Kashmir residents cannot buy land or property? Why those who are not the citizens of Jammu and Kashmir, who are not the permanent residents of Jammu and Kashmir, why can they not get scholarships in Jammu and Kashmir? Why can they not apply for government jobs? Matter went to the court. The Supreme Court said this is constitutional. Why constitutional? Because President can issue any order under Article 370 of the Constitution with the concurrence of the state government to apply other provisions of Indian Constitution to the state of Jammu and Kashmir with some exceptions, with some modifications. And the exception was Article 35 capital A. That means despite the fact that fundamental rights chapter was inserted applicable to the state of Jammu and Kashmir, but with the modification that non-residents cannot buy land, cannot buy property, cannot get scholarships, cannot apply for government job in Jammu and Kashmir. This was another exception. And over a period of time, then came another judgment, Sampat Prakash, 1968. What was this case all about? There were some preventive detention laws which were to be made applicable to the state of Jammu and Kashmir. But these preventive detention laws could have violated fundamental rights. Fundamental rights such as under Article 21 of the Constitution, under Article 22 of the Constitution. But these preventive detention laws were made applicable to the state of Jammu and Kashmir through presidential order with the concurrence of the state government, even if they violate fundamental rights. Matter went to the court. The Supreme Court was asked, how can President issue this order? Because now there is no Constituent Assembly in Jammu and Kashmir. Constituent Assembly of Jammu and Kashmir was dissolved in 1956. Now how can President issue an order and apply preventive detention laws to Jammu and Kashmir with the concurrence of the state government, thereby violating fundamental rights? Supreme Court said no. Even after Constituent Assembly of Jammu and Kashmir has been dissolved, Article 370 continues to exist. That means President can issue any order under Article 370 and apply other provisions of Indian Constitution to Jammu and Kashmir with exceptions, with modifications. Then came Maqbool Damnoo, 1972. It was an interesting case. Jammu and Kashmir had its own constitution. Jammu and Kashmir had its own flag. Just like the national flag, there was a state flag of Jammu and Kashmir. And Jammu and Kashmir, the head of the state was known as Sadr-e-Riyasat, which is the Urdu term for the president. So you had the President of India, you had the President of Jammu and Kashmir as well, known as Sadr-e-Riyasat. You had the Prime Minister of India, you had the Wazir-e-Azam for Jammu and Kashmir, the Prime Minister of Jammu and Kashmir. Something happened. Article 367 was used, which you might have read in the newspaper, something related to Article 367. What is Article 367? Article 367 deals with interpretation of the Constitution. What is interpretation? For example, there are some seats reserved for scheduled tribes. Who are these scheduled tribes? The interpretation is whatever is mentioned in the General Clauses Act of 1897. Although Constitution does not define who are the scheduled tribes, but if we have to understand who are the scheduled tribes mentioned under the Constitution, for that we have to look at the General Clauses Act of 1897. Whatever is the definition of scheduled tribes there, that is the definition of scheduled tribes in the Constitution of India. We have had reservation for Anglo-Indians in Lok Sabha, Anglo-Indians in the state legislative assemblies. Who are these Anglo-Indians? Mentioned in the General Clauses Act of 1897. And at any point in time, if we have to understand and interpret what is this provision of Indian Constitution, for that we have to look at Article 367. Article 367 will provide the interpretation of that particular constitutional provision. Article 367 was used to change the nomenclature of Sadr-e-Riyasat to the governor, to change the nomenclature of Wazir-e-Azam to chief minister. So the interpretation is, if the Constitution of India with respect to Jammu and Kashmir talk about Sadr-e-Riyasat or Wazir-e-Azam, it basically means, the interpretation is, it is the governor and the chief minister. Petitioner Maqbool Damnoo approached the Supreme Court and said, how can you do this? How can you use Article 367 to interpret what is mentioned in the Constitution of India? Supreme Court said no. Article 367 is about interpretation of some of the terms mentioned in the Constitution. So the explanation is provided. The interpretation is provided that Sadr-e-Riyasat means the governor, that Wazir-e-Azam means the chief minister. So this action of the government in the 1970s to change the nomenclature of Sadr-e-Riyasat and Wazir-e-Azam, it is constitutional. And then came 2016, SBI case, State Bank of India case. This was related to the Surfaci Act. There were two judges. One judge was Justice Rohinton Fali Nariman. And the Supreme Court said Article 370 can be abrogated, can cease to exist only after the recommendation of the Constituent Assembly of Jammu and Kashmir. I'm taking you through the history. If this is what Article 370 was in 1950, this was not the same Article 370 which was in 2019 on August 5, 2019. Because it was this Article 370 which was a tunnel through which Indian Constitution flows into Jammu and Kashmir. And one by one there were modifications, presidential orders were issued, which is basically the presidential order of 1954. And it is this presidential order of 1954 which was amended, modified multiple times to bring more integration between Jammu and Kashmir and the Union of India. And at one time on August 5, 94 of the 97 items in the Union list were made applicable to Jammu and Kashmir. There was no Wazir-e-Azam or Sadr-e-Riyasat. There was a governor and the chief minister. Various provisions of Indian Constitution were made applicable to the state of Jammu and Kashmir. And the Supreme Court upheld the validity of Article 35 capital A. The Supreme Court upheld the various presidential orders issued under Article 370 from time to time to time. Then came the BJP, the Bharatiya Janata Party, which was born in 1980. But the ancestor of BJP, the predecessor of the BJP, was Janasangh. The ideological parent of the BJP was the Janasangh. And one of the important leaders of Janasangh was Shyama Prasad Mukherjee. Dr. Shyama Prasad Mukherjee was against Article 370. So was Dr. B.R. Ambedkar. Dr. B.R. Ambedkar did not agree with Article 370. How can you create two systems in India? One for Jammu and Kashmir, one for the rest of the country. Similarly, Dr. Shyama Prasad Mukherjee, he was also not in favor of Article 370. And he said, there cannot be two flags in one country. There cannot be two heads of the states in one country. There cannot be two constitutions in one country. Because there is Constitution of Jammu and Kashmir, there is Constitution of India. There is the national flag of India, there is the state flag of Jammu and Kashmir. There is the President of India and there is the Sadr-e-Riyasat of Jammu and Kashmir. This is not acceptable. एक देश में दो विधान, दो प्रधान, दो निशान नहीं हो सकते. And Shyama Prasad Mukherjee, at that time there was a permit system in Jammu and Kashmir. Just like we have the permit system in some of the northeastern states. Without the explicit permission of the state government, you could not enter Jammu and Kashmir. Dr. Shyama Prasad Mukherjee, without taking the permission of the government of Jammu and Kashmir, entered Jammu and Kashmir. He was arrested and unfortunately he died under mysterious circumstances in a jail in Jammu and Kashmir. So since the ideological parent of the BJP was Janasangh, and Janasangh was not in favor of Article 370, this was the ideological ploy of the BJP, that we will have to get rid of Article 370, we have to abrogate Article 370. And there used to be three most important ideological objectives of the BJP. That BJP said, if we come to power with absolute majority, we will ensure that these three things are implemented. One, we need to construct a mega Ram temple at the disputed site at Ayodhya. Two, we will abrogate Article 370 of the Constitution. Three, we will enact a uniform civil code. So ideological objective of the BJP was to get rid of Article 370, to abrogate Article 370, and that is how in 2014, when elections were held to the Jammu and Kashmir Legislative Assembly, no single political party was able to form the government on its own. Two political parties, the People's Democratic Party and the BJP, with 28 seats and 25 seats between them, in an 87-member Jammu and Kashmir Legislative Assembly, they decided to come together and form the government. This government was formed in 2015. Mufti Muhammad Saeed became the chief minister. BJP had its deputy chief minister, and this government continued. Then Mufti Muhammad Saeed passed away, and then his daughter, Mehbooba Mufti, was sworn in as the chief minister of Jammu and Kashmir. But then in 2018, the BJP withdrew support to Jammu and Kashmir government. The government collapsed, and then governor's rule was imposed in Jammu and Kashmir. Because in the rest of the country, wherever there is a fall of the government, then president's rule under Article 356 is normally imposed. But not the case with Jammu and Kashmir then. If there was a breakdown of the constitutional machinery in J&K, first there has to be a governor's rule for 6 months. And this governor's rule could be imposed in Jammu and Kashmir under the constitution of Jammu and Kashmir. But if in 6 months we will not have a government, then president's rule under Article 356 shall be imposed. And in 2018, June, when the government collapsed, governor's rule was imposed in Jammu and Kashmir. 6 months passed, then president's rule was imposed under Article 356 of the Indian Constitution. And then this Jammu and Kashmir Legislative Assembly was also dissolved. This becomes very important to understand what happened on August 5 and August 6. When president's rule is imposed in a state, who takes over the executive? Who takes over the legislature? The implication of the president's rule is there is no chief minister, there is no council of ministers. So who is the executive in that state? President. That is what we call president's rule or central rule. So president will assume all the powers of the state government through his agent, who is the governor of that state. But who will make laws for that state where president's rule is imposed? That power is given to the Parliament of India, which basically means when a state is under president's rule, the executive becomes the president and the governor. Governor will take actions on the advice of the president, on the directions of the president. And when the state legislative assembly is dissolved because of president's rule, who will now act as the state legislature? That power is given to the Parliament of India. So now the state government is governor. State legislature is the Parliament of India. This is where it becomes crystal clear. Article 370 and Article 1 is applicable to the state of Jammu and Kashmir. Can other provisions of Indian Constitution be made applicable to Jammu and Kashmir? Yes. For that, what is the solution? What is the alternative? What is the provision? President will have to issue an order with the concurrence of the state government. And this is exactly what was done. On August 5, 2019, the morning, President issued an order, a constitutional order under Article 370. And this order came to be known as Constitutional Order 272. And this order said all the provisions of Indian Constitution will apply to the state of Jammu and Kashmir without any exceptions, without any modifications. And this Constitutional Order of 272 will supersede and replace the Presidential Order of 1954. When Presidential Order of 1954 was issued, through which various provisions of Indian Constitution were made applicable to the state of Jammu and Kashmir, exception was 35 capital A. that 35 capital A empowers the state legislature that you define who are your permanent residents. And then these permanent residents alone can buy land, property in Jammu and Kashmir, can get scholarships in Jammu and Kashmir, can get a government job in Jammu and Kashmir. So this 35 capital A was part of presidential order of 1954. Now, if this presidential order is issued in 2019, known as the Constitutional Order 272, this order replaces the 1954 order without any exceptions, without any modifications. So 35 capital A disappeared. Because 35 capital A was part of presidential order of 1954. This has been replaced by the presidential order of 272 of 2019. That means now the entire constitution applies to the state of Jammu and Kashmir without any exceptions, without any modifications. And how was this done? Because can other provisions of Indian constitution be made applicable to the state of Jammu and Kashmir? Yes, through presidential order, which can be issued only with the concurrence of the state government. Now, who is the state government? Governor of that state. Governor gave its concurrence and said entire Indian constitution applies to Jammu and Kashmir, which means the previous presidential order of 1954 is replaced by the presidential order of 2019 known as Constitutional Order 272. But something else. I told you about Article 367. What is Article 367? Interpretation of the Constitution. Why do we need Article 367? Because what is mentioned in Article 370, Clause 3? Notwithstanding anything mentioned in the Constitution, this Article 370 shall cease to exist, or shall exist with these exceptions and modifications, which the President by its order specify. But this presidential order cannot be issued without the concurrence of the Constituent Assembly of Jammu and Kashmir. Now, there is no Constituent Assembly. What government did? Government invoked Article 367. President said, I will use Article 367, which talks about interpretation of the Constitution. In Article 370, if there is this term known as Constituent Assembly of Jammu and Kashmir, it should be interpreted as, it should be read as, it's not the Constituent Assembly, it is the Legislative Assembly of that state. But when there is no Legislative Assembly, because the state is under President's rule, who acts as the Legislative Assembly for that state which is under President's rule? Parliament. So basically, President wanted the concurrence of the Parliament, which is acting as the Legislative Assembly of the state of Jammu and Kashmir, which is basically the Constituent Assembly of Jammu and Kashmir, to enact another order known as the Presidential Order 273, Constitutional Order 273, and said all other provisions of Article 370 are gone, except one. Article 370, which talked about various clauses. Clause 1, ABC, Clause 2, Clause 3, all these are gone. Because Article 370 can cease to exist, or can exist with such exceptions or modifications, which the President in his order will specify. But this order cannot be issued without the concurrence of the Constituent Assembly of Jammu and Kashmir. But Article 367 has been invoked to interpret that it is not the Constituent Assembly of Jammu and Kashmir, it is the Legislative Assembly of Jammu and Kashmir. But since there is no Legislative Assembly, because the state is under President's rule, and during President's rule, the Parliament becomes the Legislative Assembly for Jammu and Kashmir. So on the request of the Parliament, on the concurrence of the Parliament, which is the Legislative Assembly, which basically has been equated with the Constituent Assembly of Jammu and Kashmir, Article 370 ceases to exist, but with this exception. And the exception is, all provisions of Indian Constitution will be made applicable to the state of Jammu and Kashmir without any exceptions, without any modifications. No matter what is mentioned in any other provision of the Constitution, the entire Constitution will automatically apply to Jammu and Kashmir. And from now onwards, there is no Article 370. Article 370, Clause 1, Clause 2, Clause 3, Clause 4, gone. Only one item is there in the Article 370, which means all provisions of the Constitution will apply to Jammu and Kashmir. Whether this was done correctly or incorrectly, that was the challenge before the Supreme Court. And not only this, Jammu and Kashmir Reorganization Act was passed. And this Jammu and Kashmir Reorganization Act bifurcated the state, downgraded the state into two union territories. Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. Can this happen? Can permanent changes be made to a state when it is under a temporary provision of President's rule? This was another challenge before the Supreme Court. And now 5 judges of the Supreme Court had to decide, which they did on December 11, 2023, whether these actions are constitutional or not. And the first question that Supreme Court, 5 judges of the Supreme Court had to answer was whether Article 370 is temporary or whether it is permanent. The petitioner said their contention was that Article 370 was temporary till 1956, when we had a constituent assembly in Jammu and Kashmir. After 1956, before its dissolution, when Constituent Assembly of Jammu and Kashmir did not recommend deletion of Article 370, Article 370 has become permanent. If to delete Article 370, if to modify Article 370, you need the concurrence of the Constituent Assembly of Jammu and Kashmir, and since there is no Constituent Assembly of Jammu and Kashmir, which got dissolved in 1956, which means Article 370 cannot be touched, it has attained a permanent feature. All the 5 judges unanimously rejected this idea and said, no, Article 370 is not permanent, it is a temporary provision. How did the 5 judges arrive at this conclusion? The 5 judges said, look at Part 21 of the Constitution, which talks about temporary and transitional provisions. If Article 370 was meant to be permanent, why would Article 370 be made part of Part 21 of the Constitution with the title Temporary and Transitional Provisions? Which means Article 370 was never meant to be permanent. It was always meant to be temporary. That's reason number 1. Reason number 2, Article 370 had a self-destruct clause. Name one article of the Constitution which has a self-destruct clause. Article 370, Clause 3 itself said, notwithstanding anything, Article 370 shall cease to exist or shall exist with such exceptions and modifications. If Article 370's wording is such that it itself says that I can be destructed, which means it was never meant to be permanent, it was always meant to be temporary. The court said, don't give me this idea that Article 370 has become a permanent feature of the Constitution. Because if you are saying this, then you are elevating Article 370 to some sort of a basic structure. On 24th April 1973, in a Keshavananda Bharati versus State of Kerala, the Supreme Court said there is something known as the basic structure, which means no amendment of the Indian Constitution can alter basic structure. Are you then saying that we have a basic structure and on top of that we have a super basic structure known as Article 370, which cannot be touched, which cannot be modified after 1956? We don't agree with this reasoning. So Article 370 was meant to be temporary because it was placed under temporary and transitional provisions, because it has a self-destruct clause, because you cannot place Article 370 at a pedestal higher than even the basic structure. Justice Kaul, he had an interesting take on this matter. He said, the citizens of Jammu and Kashmir are treated differently from the citizens of the rest of the country. This may have been required in 1950s or 60s. But ultimate objective has to be that of equality. Ultimately, equality has to be there. Citizens of J&K have to be treated at par with the citizens of the rest of the country. Through this logic, we cannot anticipate that Article 370 was meant to be permanent. It was always meant to be temporary. Something interesting, and listen to me carefully. Article 370 was used by the president to issue various presidential orders, to apply Indian Constitution to Jammu and Kashmir in a piecemeal manner. One by one, provisions were made applicable of Indian Constitution to Jammu and Kashmir. But if now the government has decided that in one go, we will apply the entire Indian Constitution to the state of Jammu and Kashmir, that means we don't need a piecemeal approach. We need to apply Indian Constitution in one go. This is, my dear, a policy decision of the government. And if it is a policy decision, it is within the domain of the executive. Judiciary cannot interfere. After all, it is a policy decision because it was the policy of the government that we will not apply Indian Constitution in one go to Jammu and Kashmir. We will take a piecemeal approach. One by one, we will apply Indian Constitution to the state of Jammu and Kashmir. And now they've decided that we no longer need Article 370 because we will apply Indian Constitution in one go to Jammu and Kashmir. It's a policy decision. And the courts cannot interfere in the policy decisions of the executive. Unless and until, of course, the policy is blatantly unconstitutional. But we cannot fault the President of India and say the manner in which it was done and say the purpose behind the President was mala fide. The intention of the President was wrong in applying entire Indian Constitution to Jammu and Kashmir in one go. That is why Article 370 was never meant to be permanent. It was always meant to be temporary. That was question number one, which the court had to answer. And majority of 5-0, a unanimous verdict was given by the court, and the court said Article 370 was always meant to be temporary. Second thing that the court had to decide was, did Jammu and Kashmir retain an element of sovereignty after it signed Instrument of Accession? What is sovereignty? The term sovereignty has different connotations in political theory, in law, in philosophy. Look at the writings of Thomas Hobbes, John Locke, Rousseau. All of them have deliberated on the various definitions of sovereignty. And the meaning of sovereignty has changed, evolved over centuries. Today we can say that this body is sovereign. Listen to me carefully. We can say that this particular body is sovereign if it has unrestricted power, if it has unlimited power, and there is no other body superior to it. What is sovereignty? We say sovereignty lies with the people of India. That's how our constitution starts. We, the people of India. This ultimate sovereignty is with the people of India. Can a particular body be called sovereign? Yes. If this body has unlimited power, no restriction on its powers, and there is no other body which is superior to it. A.V. Dicey, British constitutional expert, he writes, in law of the Constitution. He says basically sovereignty is the power of lawmaking unrestricted by any legal limit. We say British Parliament is sovereign because according to the writings of D. Lolme, British Parliament can do anything except convert a man into a woman and a woman into a man. British Parliament is sovereign. It can take any decision, make any decision, unmake any decision. But do we say Indian Parliament is sovereign? Indian Parliament is not sovereign because it has limitations. It cannot violate fundamental rights. It cannot pass any law which violates basic structure of the Constitution. So Indian Parliament is not sovereign. British Parliament is sovereign. In India, sovereignty lies with the people. But did Jammu and Kashmir retain its sovereignty after signing instrument of accession? This was something that the court had to decide. And this is where there was a disagreement as well. And this time the decision was taken by majority of 4:1. 4 judges of the Supreme Court said Jammu and Kashmir did not retain its sovereignty after signing instrument of accession. One judge, Justice Cole, he basically said no, Jammu and Kashmir retained an element of sovereignty because in 1969 a 5-judge bench of the Supreme Court had explicitly said that Jammu and Kashmir has retained its sovereignty after signing instrument of accession. What does that mean? When Maharaja Hari Singh signed the instrument of accession, transferring 3 powers to the Parliament of India, retaining all other powers to himself, he publicly declared, he proclaimed that I retain sovereignty over all other items except defense, external affairs and communication. So I don't have ultimate power over these items, but I retain the ultimate powers over all other items. That means I have retained some element of sovereignty. But then why did these 4 judges say no? Jammu and Kashmir did not retain its sovereignty. These 4 judges relied on the proclamation issued by Yuvraj Karan Singh. Maharaja Hari Singh was succeeded by his son Yuvraj Karan Singh, who's alive. He's given a lot of statements. If Maharaja Hari Singh in his proclamation said, I have signed instrument of accession, transferring 3 powers, but I have retained sovereignty over other items. Yuvraj Karan Singh in 1949 issued another proclamation and said, from now onwards, since the Constitution of India is now adopted, this Constitution of India will supersede every other treaty, every other proclamation. That means it is this Constitution of India which will be supreme, not any other declaration. Which means the proclamation of Yuvraj Karan Singh is, I am giving up my sovereignty, basically saying I have merged with the Union of India. Because the petitioners argued that Jammu and Kashmir is different from various other states, various other princely states. Because those princely states signed instrument of accession and signed merger agreement. Then they merged with the Union of India. They gave up their sovereignty. But Jammu and Kashmir did not. Jammu and Kashmir only signed instrument of accession, did not sign the merger agreement. When we did not merge, that means we retained our sovereignty. The Supreme Court relied on the proclamation issued in 1949 by Yuvraj Karan Singh to say, no, this proclamation means you have merged with the Union of India, which means even though you did not sign the merger agreement, this declaration by the Maharaja, by the Yuvraj Karan Singh, that I am giving up my sovereignty, it means that you are merging with the Union of India. You have not retained an element of sovereignty. Maximum we can say that Article 370 was asymmetric federalism. Just like we have asymmetric federalism for some other states. Article 371. There are some special provisions for states such as Maharashtra, Gujarat, Manipur, Meghalaya, Mizoram, Nagaland, Goa, the 6 backward districts of Hyderabad, Karnataka region, Article 371, capital J. Does that mean that all the 28 states that we have and the Union of India that we have, the relationship is common for all? No. That would have been symmetric federalism. We follow asymmetric federalism, where there are special provisions for the tribal areas. There are special provisions for Vidarbha. There are special provisions for Nagaland, for example. In Nagaland, if Parliament has passed a law on land, on the cultural customs of Nagaland, it will not be applicable to Nagaland unless and until the Legislative Assembly of Nagaland explicitly accepts it. Similarly for Mizoram. That means we follow asymmetric federalism. This asymmetric federalism, we can say we followed for J&K as well. But don't confuse, don't conflate asymmetric federalism with sovereignty. Jammu and Kashmir did not retain sovereignty after signing Instrument of Accession. The court relied on something else as well. What did the court rely? Court said, look at the constitution of Jammu and Kashmir. Listen to me carefully, very interesting point. We have the constitution of Jammu and Kashmir. Who has the power to amend the constitution of Jammu and Kashmir? The Legislative Assembly of Jammu and Kashmir. But this power to amend the constitution of Jammu and Kashmir has to be with 3 major qualifications. Jammu and Kashmir Legislative Assembly has some restrictions in amending the constitution of J&K. What are these restrictions? Number 1, Constitution of Jammu and Kashmir says, Jammu and Kashmir is and shall always remain an integral part of India. This cannot be amended by Jammu and Kashmir Legislative Assembly. So how can we say J&K has retained its sovereignty when it cannot change this article of J&K Constitution? Qualification number 1. Qualification number 2. All the powers that are now transferred to the central government, to the union government, cannot be taken back by Jammu and Kashmir Legislative Assembly by amending J&K Constitution. That means there is a limitation. How is it sovereign? Third qualification. Constitution of India in its application to Jammu and Kashmir cannot be amended by Jammu and Kashmir Legislative Assembly. What does that mean? Parts of Indian Constitution other than Article 1 and Article 370 shall apply to Jammu and Kashmir with some exceptions and modifications. But who can modify Indian Constitution in its application to Jammu and Kashmir? President of India. Can this Indian Constitution, as it is applicable to Jammu and Kashmir, be modified by Jammu and Kashmir Legislative Assembly? No. So how can we say Jammu and Kashmir retained its sovereignty after signing Instrument of Accession? So challenge number 1, is Article 370 temporary or permanent? Court by a majority of 5:0 said Article 370 is temporary, was meant to be temporary, it was never meant to be permanent. Question number 2, did Jammu and Kashmir retain its sovereignty after signing Instrument of Accession? 4 judges said no. Maximum we can say that through Article 370 Jammu and Kashmir followed asymmetric federalism. But you cannot conflate asymmetric federalism with sovereignty. No. But one judge, Justice Sanjay Krishan Kaul, he disagreed with the rest and said no, Jammu and Kashmir retained an element of sovereignty after signing Instrument of Accession because of Prem Nath Kaul judgment of 1969. Another challenge was to Constitution Order 272, which was issued on the 5th of August 2019. A part of this constitutional order was declared unconstitutional by the Supreme Court. What happened because of Constitutional Order 272? President issued an order with the concurrence of the state government, headed by governor, to apply entire Indian Constitution to Jammu and Kashmir, replacing the presidential order of 1954. This is valid, says the Supreme Court. But what is unconstitutional is because of this presidential order, you used Article 367 to interpret that Constituent Assembly mentioned in Article 370 is to be read as, is to be interpreted as the Legislative Assembly of Jammu and Kashmir. This is unconstitutional. Why? Because what you cannot do directly, you cannot do that indirectly. This is a classic example of colorable legislation. What does that mean? Listen to me carefully. Article 1 and Article 370 apply to Jammu and Kashmir. Clear? Using Article 370, other provisions can be made applicable to Jammu and Kashmir. When we say other provisions, that means other than Article 1 and Article 370. That means Article 1 applies to Jammu and Kashmir without exceptions. Article 370 applies to Jammu and Kashmir without exceptions. Other than Article 1 and Article 370, can we apply other provisions of Indian Constitution to Jammu and Kashmir? Yes, through exceptions as well, through a presidential order. But can you use Article 370 to amend Article 370 itself? No. What is the only way in which you can say that Article 370 ceases to exist? If you get the concurrence of the Constituent Assembly of Jammu and Kashmir. That means there is explicit route provided to the President to say that Article 370 ceases to exist. For that, you just have to issue an order with the concurrence of the Constituent Assembly of Jammu and Kashmir. But can you use Article 370 to amend Article 367, which basically means amending Article 370 itself? Because what Article 367 said? Interpretation. That means in Article 370, the term Constituent Assembly means Legislative Assembly, which means you are using Article 370 to amend Article 370 itself. This is unconstitutional. And when this is unconstitutional, the Supreme Court but said that yes, you could have applied entire Indian Constitution to Jammu and Kashmir. For that, you don't even need the concurrence of the state government. You don't even need the concurrence of the union government. You don't even need concurrence of the Constituent Assembly of Jammu and Kashmir. Till 1956, when there was Constituent Assembly of Jammu and Kashmir, you needed its concurrence to make any changes to Article 370. But now, since there is no Constituent Assembly, President has retained its power to say that Article 370 ceases to exist. President does not need concurrence of the Constituent Assembly of Jammu and Kashmir. So, this constitutional order of 272 is valid. Entire Indian Constitution applies to Jammu and Kashmir. But the route that you are taking, by interpreting Article 367 to say that Constituent Assembly in Article 370 means Legislative Assembly, this is unconstitutional. This route you cannot take. This was one aspect, one action of the central government, which the Supreme Court declared is unconstitutional. But even if this route is unconstitutional, the effect is constitutional, which means entire Indian Constitution is applicable to Jammu and Kashmir, because President, in his application of entire Constitution to J&K, he does not need permission, consultation, concurrence of any entity. It's an independent power of the President. Which means by that logic, Constitutional Order of 273 is valid. Because Article 370 Clause 3 says, Article 370 shall cease to exist or shall exist with these exceptions and modifications, but with the concurrence of the Constituent Assembly of Jammu and Kashmir. Since there is no Constituent Assembly of Jammu and Kashmir, President can issue an order It's an independent power of the president to declare that Article 370 ceases to exist. And that's how constitutional order of 273 is constitutionally valid. So what government did on August 5 and August 6? What happened on August 5? Entire Indian Constitution was made applicable to Jammu and Kashmir through Article 370. What happened on August 6? Article 370 ceases to exist. So clause 1, clause 2, clause 3 are gone. Now only this is the text of Article 370. This is constitutional. Because to issue such an order, you don't need concurrence of Constituent Assembly. So both these actions are constitutional. But the route that you have taken for Constitutional Order 272 to replace Constituent Assembly with Legislative Assembly, that is unconstitutional. But the effect is constitutional. Then the challenge was, what happens to Jammu and Kashmir Constitution? Supreme Court said that now Jammu and Kashmir Constitution is inoperative. Which means when entire Indian Constitution was not made applicable to Jammu and Kashmir, there were some gaps. These gaps were filled by Jammu and Kashmir Constitution. Now there is no gap because entire Indian Constitution is applicable to Jammu and Kashmir. So we don't need Jammu and Kashmir Constitution, which means Jammu and Kashmir Constitution is inoperative. It's gone. Then the challenge was on Jammu and Kashmir Reorganization Act of 2019. And this is where it becomes interesting. Even more interesting and fascinating. Because one part of this question was left unanswered by the Supreme Court. What is that part? Listen to me carefully. On August 5, 2019, when Article 370 was still there in the morning, Article 3 was not applicable to Jammu and Kashmir. Under Article 3, Parliament has the power to bifurcate a state, to divide a state, to merge two or more states, to increase the area of a state, to decrease the area of a state, to alter the boundaries of the state, to change the name of the state. That's the power available with the Parliament under Article 3. But this article is not applicable to Jammu and Kashmir, when Jammu and Kashmir had a special status. Which means Parliament could not have increased or decreased the area of Jammu and Kashmir or changed the name of the state of Jammu and Kashmir without the concurrence of the state. But when on August 5, 2019, entire Indian Constitution is made applicable to the state of Jammu and Kashmir, which means Article 3 is also applicable. Which means now under Article 3, Parliament can do anything with Jammu and Kashmir. Increase the area, decrease the area, alter the boundaries, change the name, bifurcate the state, merge the states. And because of Jammu and Kashmir Reorganization Act, 2 union territories were created. Union Territory of Jammu and Kashmir, Union Territory of Ladakh. Listen to me carefully. A bill under Article 3 can be introduced in the Parliament only after seeking the views of the Legislative Assembly of the state concerned. What is the procedure to reorganize the states? A bill has to be introduced in the Parliament, whether Lok Sabha or Rajya Sabha. But this bill cannot be introduced in the Parliament without the prior approval of the President of India. But President cannot give his approval to introduce this bill in the Parliament without referring this bill to the legislature of that state which is going to be affected by this bill. So if at all Jammu and Kashmir Reorganization Bill was to be introduced in the Parliament, before President can give his permission, this bill had to be referred to Jammu and Kashmir Legislative Assembly to seek the views of the Jammu and Kashmir Legislative Assembly. But since there is no Jammu and Kashmir Legislative Assembly, can in such a situation Jammu and Kashmir reorganization bill could have been passed? That is the question, that is the key question, because it is not just concerning Jammu and Kashmir, it concerns the entire country. Can permanent changes be made to a state when it is under president's rule? Because president's rule by its very nature is temporary. What is the maximum constitutional validity of a president's rule? 3 years. Beyond which you cannot extend president's rule in a state. But can, during president's rule, which is of temporary nature, can permanent changes be made to the constitution? That was the question before the court. And what the government did? Tried to introduce Jammu and Kashmir reorganization bill in the parliament. But this bill has to be first taken the approval of the president. But president, before giving his approval, will have to refer this bill to the legislature of that state which is going to be affected by this bill. But since Jammu and Kashmir does not have a legislative assembly, it is under president's rule. During president's rule, parliament is the legislature of that state. So president asked the parliament, what are your views on Jammu and Kashmir Reorganization Act? This Jammu and Kashmir Reorganization Act was first introduced in Rajya Sabha, passed by Rajya Sabha, then sent to Lok Sabha, passed by Lok Sabha. Jammu and Kashmir Reorganization Act was passed. Jammu and Kashmir was downgraded and bifurcated into union territories of J&K and Ladakh. Supreme Court had to decide two things. Are these views necessary? Now listen to me carefully. When the state is under president's rule, who has the power to make laws for that state? Parliament. That means parliament normally has law-making power for that state. Only law-making power. But law-making power is different from giving views. That means can during president's rule a reorganization of that state take place? Because we have to seek the views of the Jammu and Kashmir Legislative Assembly, or we have to seek the views of that state. Since there is no legislative assembly, can it happen or not? That's for the court to decide. Plus, can the entire state be downgraded and converted into union territories? Because the explanation of Article 3 is, a part of that state can be converted into a union territory. That much is understood. So if this is Jammu and Kashmir, a part of it is taken away and converted into a union territory. Let's say Ladakh was part of Jammu and Kashmir, it was taken away and converted into a union territory. This is mentioned in Article 3. This is mentioned in the explanation of Article 3. Yes, a part of that state can be converted to a union territory. But can the entire state be converted into a union territory? That's the question. Why? Because in S.R. Bommai versus Union of India, the Supreme Court has said federalism is part of the basic structure. What is federalism as part of the basic structure? Listen to me carefully. Article 1. India, that is Bharat, shall be a union of states. This term, union of states, Dr. B.R. Ambedkar says means federation, which means we are a federal polity. And in federal polity, there is distribution of powers between center and the state. There is dual government, one government at the center, government in every state. That means India, that is Bharat, shall be a union of states. That means Indian constitution is federal. And federalism, Supreme Court has said, is part of the basic structure. And states share federal relationship with the union because there is distribution of powers, there is dual government, so on and so forth. If for that matter, what happened in Jammu and Kashmir is right, that means entire J&K is converted to a union territory, which means all the 28 states that we have right now, they can also be converted into union territories. Karnataka converted into union territory, Madhya Pradesh, Chhattisgarh, Punjab, Rajasthan, Uttar Pradesh, all converted into union territories. That means then Article 1 would be read as India, that is Bharat, shall be a union of union territories. And union territories are directly controlled by the center. There is no dual government, there is no distribution of powers. Can the parliament use Article 3 to convert our federal polity into a unitary polity? Can Article 1 become India, that is Bharat, shall be a union of union territories? Can this happen? If it can happen to Jammu and Kashmir, it can happen to other states as well. That means we are not a federal polity, we are a unitary polity. Can this happen? Supreme Court did a somersault on this. Supreme Court said, whether conversion of Jammu and Kashmir to a union territory is right or wrong, we will leave this question open. We will not comment on this. Why? Because we have an assurance by the Solicitor General of India. Solicitor General of India has said that Jammu and Kashmir as a union territory is only for a time being. It's a temporary phenomena. It will be given statehood back. So since conversion of J&K into a union territory is not a permanent thing, it's only temporary, Solicitor General has promised that we will restore statehood to Jammu and Kashmir. We will not discuss this question whether this was right or wrong. But conversion of Ladakh into a union territory is constitutional. Why constitutional? Because Article 3 allows it. Article 3 allows a part of that state to be converted to a union territory. But can the remaining part be also converted to a union territory? We will leave this question open. We will not answer this. Why? Because Solicitor General has said Jammu and Kashmir, UT, is only for temporary period. It will be restored statehood. But conversion of Ladakh to a union territory is valid. Also, these views are not necessary. When Andhra Pradesh was reorganized in 2014, a bill, Andhra Pradesh Reorganization Bill, was sent to Andhra Pradesh Legislative Assembly asking the views of Andhra Pradesh Legislative Assembly. What are your views on this bill? Andhra Pradesh Assembly vehemently, unanimously rejected this bill and said we don't want bifurcation of Andhra into Telangana and Andhra Pradesh. We want a united Andhra Pradesh. These views are not binding on the government, are not binding on the president. Court said if these views were binding, then we could have thought whether during President's rule, when there is no legislative assembly, can during this period such a bill under Article 3 be introduced or not. But since in any case the views are not binding, that means we don't have to take that route. And since Article 3 allows converting a part of that state to a union territory, conversion of Ladakh to a union territory is constitutional. But what about conversion of the rest of the state into a union territory? We will leave this question open. If government does something similar again, we will then decide whether this is right or wrong. Right now, we will not answer that question. That is why I told you right at the start that there was one question which was left unanswered by the Supreme Court. Because the Solicitor General has promised that we will restore statehood to Jammu and Kashmir. Then, another interesting thing about this judgment. What is the title of this judgment? You may have heard of Keshavananda Bharati versus State of Kerala, S.R. Bommai versus Union of India, Sampat Prakash case, Maqbool Damnoo case. We have discussed so many cases today. What is the name of this case? It is called Re Article 370 of the Constitution. Why this title? Why not something else? The first person to file a case challenging these decisions, the name of this person was M.L. Sharma, Advocate M.L. Sharma. But Mr. Sharma is known to file frivolous public interest litigations. So since M.L. Sharma is the first person to challenge Article 370 abrogation, he wanted this case to be known as M.L. Sharma versus Union of India. So you filed the case in the first instance before anybody else, just so that the case title comes in your name. Supreme Court said, Mr. M.L. Sharma, this case will not be in your name because you are known to file these frivolous public interest litigations. Then the person who filed this petition next was Dr. Shah Faisal. a 2009 IAS topper from Jammu and Kashmir. He resigned from IAS, protesting against the government. And then he also filed this challenge before the Supreme Court, challenging the government actions on Article 370. So this case then came to be known as Shah Faisal, Dr. Shah Faisal versus Union of India. But then Dr. Shah Faisal was booked under Public Safety Act. He spent some time in jail. Then he had a catharsis, and then he said, I want to continue to be part of the bureaucracy. His resignation from IAS was rejected by the government. Then he was rehabilitated again. Now he is part of the IAS. And when this case came to be heard by the Supreme Court, he withdrew from this case. I don't want to challenge the government actions on Article 370. And then the court had to decide if ML Sharma versus Union of India cannot be the name, if Dr. Shah Faisal versus Union of India cannot be the name, then what should be the name of this case? It was decided that this case will be known as Re regarding Article 370 of the Constitution. Another interesting anecdote on this particular case. Now this Article 370, when we analyze it, was it a special status for Kashmir or was it a special status for Delhi? There are some constitutional experts who say it was not a special status for Jammu and Kashmir. It was a special status for Delhi. Why Delhi? I'll give you one example. What is the maximum constitutional validity of President's rule under Article 356? 3 years. 3 years. If President's rule in a state has to be extended beyond 3 years, for that what is required? A constitutional amendment under Article 368. And this has happened. When President's rule was to be extended beyond 3 years in Punjab, Constitution was amended, which requires a tougher majority. When it was to be continued, extended again in Punjab beyond 4 years, Constitution was amended under Article 368. But do you know, when Article 370 was in place, there was no maximum limit of President's rule under Article 356 for Jammu and Kashmir. Because for that, President had to issue an order. Article 368 was not to be invoked. Just look at the way how Article 370 was diluted, was made de-operationalized. President issued an order without taking recourse to Article 368. President could extend preventive detention laws to Jammu and Kashmir even if it violates fundamental rights. For that, President has to issue an order. President can extend any provision of Indian Constitution to Jammu and Kashmir with exceptions and modifications as the President will specify. So some constitutional experts say it was meant to be a special status for Delhi, not a special status for Jammu and Kashmir. But then let's look at the larger issues surrounding this verdict. And I will take 10 more minutes, but listen to me calmly and patiently. Issue number 1. The Supreme Court said, restore statehood in Jammu and Kashmir as soon as may be. Directed the Election Commission of India to organize elections by September 2024. That's what the Supreme Court has said in its verdict on December 11, 2023. But what is the problem with this? Article 324 of the Indian Constitution creates a constitutional body known as the Election Commission of India. The same Supreme Court has said that the powers of the Election Commission are superintendence, direction, conduct and control of all elections. All these powers are plenary in character. Unrestricted power. That means no other entity can direct the Election Commission to hold elections. How can Supreme Court direct Election Commission to hold elections in Jammu and Kashmir by September 2024? How can the Supreme Court, which is a constitutional body, direct another constitutional body known as Election Commission of India to hold elections by this particular date. How is this possible? Not just how is this possible, this was not pleaded by any petitioner. No petitioner asked the Supreme Court to direct Election Commission to organize elections. Petitioners asked the Supreme Court to decide whether the way Article 370 was diluted or not, whether that is constitutional or not. The Supreme Court was asked whether Jammu and Kashmir Reorganization Act is constitutional or not. No petitioner asked the Supreme Court to direct Election Commission of India to hold elections in Jammu and Kashmir. When this was not prayed for by any petitioner, how did Supreme Court direct Election Commission to organize elections? Number one. Number two, why September 2024? Why not April and May 2024 when there will be Lok Sabha elections in the rest of the country? Isn't this date, September 2024, arbitrary, without any logic? Why September? Why not April? Why not May? Why not now? Problem number one is you should not have directed Election Commission to hold elections. Why? Because that is not your power. You cannot direct another constitutional body. Not just that, when nobody prayed for this directive, why did you issue? Not just that, why this date, September 2024, it is arbitrary, irrational. That's problem number one. Problem number two, this is a classic case of judicial evasion. What is judicial evasion? Let's suppose I am delivering this lecture right now, which I am. I enjoy a fundamental right under Article 21, which is right to life and personal liberty. What if the police enters the studio, arrests me, detains me, but my arrest, my detention is unconstitutional because I have not committed any crime, I have not violated any law. I will approach the Supreme Court under Article 32. Or you will approach the Supreme Court under Article 32 on my behalf, saying our beloved teacher has been arbitrarily detained by the police. The government will be asked, come here, habeas corpus has been filed. Why have you arrested this teacher? What if the government says, this arrest is meant to be temporary. We will release this teacher in some days. Can the court, should the court say, okay, you have filed habeas corpus petition because your teacher has been arbitrarily detained by the police. We will not issue any directive. Why? Because the police has said this is not meant to be permanent. This is meant to be for temporary period. After some time, they will release you. Can this happen? Is this not violation of fundamental rights? It is. And the Supreme Court is the protector of fundamental rights. Supreme Court had to decide whether Jammu and Kashmir's conversion from a state to a union territory is constitutional or not. What the Supreme Court said, we will not decide on this issue. Why? Because the Solicitor General has said that a time will come when we will restore statehood. Supreme Court, please decide now whether this was right or wrong. Because this will have far-reaching ramifications for the federal polity of India. Should you wait for another state to be downgraded to a union territory, then you will wake up and decide whether this was right or wrong. This is a classic case of judicial evasion, where the judiciary is evading its responsibility and not deciding on constitutional matters, basically deferring to the executive. That's why some constitutional experts, they say, Supreme Court is no longer a constitutional court. It is an executive court, basically ratifying any decision taken by the executive, any action taken by the executive. That's problem number two. Problem number three, Constitutional Order 272, issued on August 5, 2019. What did the Supreme Court say? Using Article 367 to replace Constituent Assembly with Legislative Assembly is unconstitutional. When it is unconstitutional, doesn't it also mean that Constitutional Order of 272 itself is unconstitutional? The route that you have taken to de-operationalize Article 370, that route is unconstitutional, says the judiciary. But in the very next breath says, but applying entire Indian Constitution to Jammu and Kashmir is constitutional. These two don't add up. Although not recommended by 4 other judges, but this was part of the separate judgment given by Justice Call, wherein he said that we need to set up a Truth and Reconciliation Commission. Just like something was done after apartheid in South Africa, which was headed by Reverend Desmond Tutu. Basically, all those whose rights have been violated by the state, they would come and appear before the Truth and Reconciliation Commission, basically give proof of how they were tortured by people, by state, by other authorities, so that first there has to be truth, and then we can have reconciliation. Justice Sanjay Krishan Kaul, he rightly remarked that Jammu and Kashmir is a political issue and needs to be resolved politically. He said, not my words, his words, that there have been allegations of human rights violations against the security forces. First, we need to accept the truth that yes, it may have taken place. Only then reconciliation can take place, because there is a trust deficit between the state and the people of Jammu and Kashmir. That trust deficit can be bridged only if we have a Truth and Reconciliation Commission. But Justice Kaul further argued, it's a sensitive matter and it is for the government to decide how and in what form can this Truth and Reconciliation Commission be set up. But perhaps the scathing criticism of the actions of the government on Jammu and Kashmir are, these actions have had far-reaching consequences on the future of Jammu and Kashmir. Could such actions have been taken without any representation from Jammu and Kashmir? Without consulting anybody from Jammu and Kashmir? Without consulting the people of Jammu and Kashmir? Could such decisions have been taken? This is where some experts, they cite a poem, a satirical poem written by Mr. Brecht, known as The Solution, which was written in the aftermath of the East Germany uprising of 1953. It was a satirical poem written, which was not published at that time, but was published later because it was highly critical of the government. This poem read, after the uprising of the 17th of June, the Secretary of the Writers' Union had leaflets distributed, which stated that the people had lost the confidence of the government and could only win it back by redoubled work. Would it not, in that case, be simpler for the government to dissolve the people and elect another? You don't like a particular government, you don't re-elect the government, you replace it with another representative set. That's how the people can impose a check on the government. Without taking the people in confidence, if you are taking such actions and such decisions with scant disregard to the wishes of the people, it may also mean, in a satirical manner, as written by Mr. Brecht, that it's for the government to dissolve the people and elect another set of people. That is all that you need to know regarding the Supreme Court verdict on Article 370. But there are two more issues that we need to discuss. One, during President's rule, any actions taken by the government, are they subject to judicial review? The Supreme Court has said, after the proclamation of President's rule, any action taken by the government can be subject to judicial review, but the petitioner has to prove before the court that prima facie, on the face of it, the action of the president was malified, it was bad intention on part of the president to make certain decisions. And when I told you that when a reorganization bill is to be presented to the parliament, before it can be presented to the parliament, it needs to be sent to the legislature of that state which is going to be affected by this bill, seeking the views of that state. The petitioners had argued that although during President's rule, the power to make law for that state is vested with the parliament, but it is only law-making power. It's not the power of the parliament to give its views on behalf of the legislature. The Supreme Court said, no, this line of reasoning we will not accept. The power of Parliament under Article 356 to exercise the powers of the legislature of the state cannot be restricted to law-making power, thereby excluding non-law-making power. And what is that non-law-making power? Expressing views on a reorganization bill. This, the Supreme Court said, we cannot restrict only law-making powers under Article 356. When the state is under President's rule, Parliament assumes all the powers of the state legislature, law-making powers as well as non-law-making powers, which includes the power to make views, to give views on the reorganization bill, which means the interpretation would be that tomorrow President's rule can be imposed in any state. When the President's rule is imposed, the Parliament becomes the legislature of that state. And then the Parliament will give its views on that reorganization bill. Although it's not a law-making power, but even a non-law-making power can be usurped by the Parliament when President's rule is in place. That is it about the Supreme Court verdict on Article 370. If you have liked this video, if you have understood all these concepts, please don't forget to press the like button. Drop in your comments, even if you have some queries, concerns, issues, or you want some clarification on some of the topics that we discussed. Please drop in your comments. I will be more than happy to respond to all your comments. Thank you so much for staying with me on Tuesday night. Good night. Stay safe.